We've been talking more than a little bit about some of the things that are going on in Washington, D.C., the debates, the presidential race, and, of course, the coming confirmation of Amy Coney Barrett to the United States Supreme Court, Donald Trump's third pick for the court. John Malcolm joins me now, who's vice president for the Institute for Constitutional Government and director of the Meese Center for Legal and Judicial Studies. John, it's good to have you back on the program. I want to talk about Amy Coney Barrett and about one specific concern. If you could address this one. The concern, and it's being talked about by a number of people who say Amy Coney Barrett as a justice could be the deciding vote to find Obamacare unconstitutional. A lot of us, and I'll include myself in this group, have believed that it was unconstitutional all the way along, and that Chief Justice John Roberts actually wrote into Obamacare things, or effectively wrote into it, things that the Congress never said, and that's the kind of activist judge that the Supreme Court does not need. And there's a concern now that because Judge Barrett has been critical of John Roberts' decision to do that, means that she may be the vote that finally finds Obamacare unconstitutional, which I think would be a victory.
Well, that's an awful lot of maybes, and as I sometimes say, my crystal ball broke yesterday. So let's state the obvious, which is that the late Justice Ginsburg, in the two previous Obamacare cases, NFIB versus Sebelius and King versus Burwell, voted with the majority to uphold Obamacare. Chief Justice Roberts wrote both of those opinions, and Amy Coney Barrett, as a professor, has written an article criticizing Chief Justice Roberts, saying that those were poorly reasoned, atextualist opinions. And so, is it possible that a Justice Barrett could provide a vote to overturn Obamacare? Yes, it is possible. On the other hand, the legal arguments in this case are completely different from the two previous cases that have been before the court. So I think it was in 2017, 2018, Congress eliminated the tax, or call it a penalty, call it a tax, whatever it was that somebody was going to be charged if they did not comply with the individual mandate was eliminated. So the question is, well, okay, if you undercut the basis under which the original individual mandate was upheld as part of the taxing power of Congress, what happens to the individual mandate? And, that's a very fair question, and it's quite possible that you could say, well, the individual mandate exists on paper only. But even if you do that, or even if you strike the individual mandate, the Supreme Court might very well come to the conclusion, I don't know whether they will or not, that provision is severable from the rest of the Affordable Care Act. In the original case, they said that it didn't appear as if it was going to be severable because they needed all those people to sign on or that money to make the system work. I don't know how well that argument works now, several years later, when there have been experience with these exchanges and how well the system has worked without people paying these penalties. So all of that is to say, could be, but there are different legal arguments. She will, during the confirmation hearing, follow the Ginsburg rule of offering no forecasts or hints as to how she would rule as a justice if confirmed with the court. And
which I'm glad for.
She has done, and she'll approach this with an open mind and consider the arguments in briefs of counsel.
Well, and John, listen, I've stuck to that rule. I got educated on this when I was about 20, and I was a reporter, and I encountered a judge at some social get-together, and I was talking to him, and I've done this with a couple of judges and said, well, what do you think about these issues? And he'd say, I can't tell you, because I can't give an opinion, even in informal circumstances, about something on which I might be ruling. And as a reporter, the minute he said that, I thought, oh, well, that makes sense. You can't have judges running around saying, oh, anytime an abortion case comes to me, I'll decide in favor of life. And anytime a Second Amendment case comes to me, I'll decide in favor of the gun owner. You can't have judges like that. And I don't care if I agree with the judge or not agree. I don't want judges that prejudge cases before they ever arrive. So I appreciate that. But do you think that we will see some senators who will vote no on Judge Coney Barrett for confirmation of the Supreme Court because they think they've intuited how she is likely to judge that case in particular, since, the Democrats find this so very, very important to them, and that because of that, they may not say it out loud, but they'll be voting against her in part because they think she'll find Obamacare unconstitutional?
Well, the Democrats are going to be talking a lot about this during the confirmation hearing, and they've all made it pretty clear. She is not. If she gets confirmed, it will be without a single Democratic senator voting to confirm her. So really what we are talking about is 2 or 3 Republican senators. So Susan Collins has already said before the nomination was announced that she was a no vote because she wanted this to be held after the election. Lisa Murkowski said she preferred to hold it after the election, but she hasn't definitively said that she's going to vote against Amy Coney Barrett. And so now we're, going to look at Lisa Murkowski and Mitt Romney and maybe a few other senators to see how they vote. I don't think that this is going to be the deciding feature for them. She has said she's going to keep an open mind. Not only the right thing and not in terms of prejudging cases, but you want to consider the legal arguments of counsel, and each one of these cases presents unique legal questions. So I don't think that this is going to be, a no vote or the straw that breaks the camel's back for any of these Republican senators, but they'll have to examine their own consciences and decide how they feel after she appears before them in a couple of weeks.
Well, John, let me ask you, what about the appropriateness of somebody saying, I don't want to vote on this now, I want it to be put off till after the election, but then when your colleagues have decided there will be a vote, is that a legitimate reason to vote no as a protest against when the process happens, rather than to do what the Constitution says, which is advise and consent? Make a decision. Is this candidate, we're going to make the decision on this candidate now. McConnell says there will be a vote. Can you then vote no as a protest against the process? I mean, I know you can, but should a senator now vote no because they don't like the process, even though they might say, well, the candidate is perfectly acceptable, which I think she is?
This is a little bit like the confirmation process, a little bit like the impeachment process, which is each of these senators is a judge, and they get to decide for whatever reason they want to and whether they consider it legitimate. Would I vote that way? No, I would not. I would consider the merits of the nominee and vote the nominee up or down, or join my colleagues and say we are just going to withhold our advice and consent altogether and not hold a hearing. But each one of these senators is their own judge, and each one's vote counts as much as everybody else's. And they'll all have various reasons for whether they vote to confirm or deny or abstain, if you will, from voting to confirm, and that's the way the system's set up.
John, let me take the judge a place where a layperson would take it. I know that one of your legal students wouldn't do this, but if I were a judge and I said, I'm hearing this murder case, and it's a murder case involving 2 murders, I want to wait and decide this case until after his co-defendant has been tried. And you say, no, you have to decide it now. Well, because you're making me decide it now, I'm going to vote that he's not guilty, or vote that he's guilty. I mean, the judge will decide that he's not vote, but he will decide that the defendant is guilty, because he's objecting to the process. That's the problem I have. I don't want a judge to say, well, I don't want to decide it now. Well, you have to decide it now. Well, in that case, I'll give you a decision you don't like. That just doesn't seem like, when you put it as these are all judges, it seems the judge, if called upon to make a decision now, should make the decision. Even if the judge doesn't want to make the decision now, they have to make the decision now. That's what their colleagues have decided.
Yeah, look, it's a fair point, and I agree with you. If I were a sitting senator, that's what I would do. But there have actually been Supreme Court justices who have been nominated, shot down, and then renominated. So I suppose somebody would sit there and say, well, I'm voting no now, but if you win the election, you want to renominate her, go right ahead. I'm not saying that's the right thing to do. It certainly wouldn't be what I would do. But, these are many judges, and they can decide they just don't like the nominee, or they can decide they just don't like the process, or they can decide I don't like the process, but she's qualified, and I'm going to vote to confirm her. And that is what I'm hoping Lisa Murkowski decides to do, but we'll see.
Yeah, let's see. They can afford to lose 3, can't they? 3 votes and still have Mike Pence to break the tie? Yeah. Do you think Pence is going to end up voting?
Vote? No, I think she's going to get at least 51 votes and possibly 52. Collins is definitely no. She won't get a single Democratic vote, but I think that she will get a majority.